orgasmic. Order more acid, more than 4 tablets. Portal door passage, born before mortal war happened. We were lords way before we were poor black men. Now we like Catherine, only having 4 Jacksons. Swore to pure magic, slaughter 4 dragons. Heat like corduroy fabric, door-to-door tactics. Easy like tortoise on boarded floor backspins. Rapping like the man that created.
Greetings, nobles and noble women. Welcome to the Trust Issue Cipher. This is your brother Usman, and today's topic, we're going to talk about minimum contacts. Now, I want to discuss this particular topic because a lot more people are interested in trust, and many want to start out with private trust. Now, on the one hand, I think it's because people are becoming more savvy about the protection a private trust provides, and they want to jump right in without being tied to the state necessarily. I understand the motive, especially considering the current times. So we're going to give out that information and see if we can bring a little clarity to that type of decision. So, what is a minimum contact? Now, I'm going to explain what a minimum contact is and show you how the courts interpret these minimum contacts as well. So you can get pretty much a full rounded view of how to keep your trust out of undesired jurisdictions. Now, it might get a little hazy at first, but I'm going to try to make it as clear as possible. So first, we're going to go to the Cornell West School of Law. It reads minimum contacts as thus. Minimum contacts, according to Cornell West School of Law. A non-resident defendant's connections with the foreign state, i.e. the state where the lawsuit is brought, that are sufficient for jurisdiction over that defendant to be proper. Lack of minimum contacts violates the non-resident defendant's constitutional right to due process and offends traditional notions of fair play and substantial justice. Examples of minimum contacts include. Now, when we see include, okay, we know that the examples they give here are not the end-all be-all of what constitutes minimum contacts. All right? It's not the entire definitive scope. They're just giving us a few examples of what can constitute minimum contacts. All right? But reading on. Minimum contacts include conducting business within a state, incorporating in that state, and visiting the state. Okay? Now that sounds very ambiguous on purpose. So let's go to another source. We're going to go to the Fine Law Legal Dictionary, where we have minimum contacts as the level of non-resident defendant's connection with or activity in a state that is sufficient under due process to support the assertion of personal jurisdiction under a long-arm statute. And for the record, a long-arm statute is a rule that gives a court the right to claim personal jurisdiction over a foreign or out-of-state person on the basis of certain acts committed by that person. So let me clarify what they're talking about here. If I owned a corporate business in California selling shoes and became a multimillionaire, then I started shipping my shoes to other states, say Nevada, and sold $1 million out there. If I don't allot taxes from these sales for the state of Nevada, they can do what's called an assessment by distraint. And what they do, all right, if they found me doing business in their state, which is foreign to my corporation, they pull up on the venue I have my inventory, be it a store or a warehouse, and they would take everything. They would file a suit against me in court, and if I don't go to the state, to that particular state, if I don't go to Nevada to defend that case, they can sell my inventory and pay the taxes they claim I owe. Okay, that's a long-arm statute. Now bear with me. The final source I'm going to take you to is Wikipedia. And by the way, I know some people don't trust Wikipedia as a trusted source of information, but all information has components of relative truth. If you do research on any level, you know what I'm talking about. Wiki and other references either omit or misstate some information. And know that to misstate is different from misrepresentation. But I've seen this done with Wiki and other sources. That said, you can always cross-check Wiki references because they give them at the bottom of each article piece. And also, if you omit something from a narrative, most of the time that cannot be done without leaving a void in the storyline, which makes real researchers go look elsewhere for that information, thereby making said researcher more informed, than probably intended for him or her to be. So if you're a researcher, you know what I'm talking about. But, I digress. Let me get back to the point. In Wikipedia, minimum contacts is described as minimum contacts is a term used in the United States law of civil procedure to determine when it is appropriate for a court in one state to assert personal jurisdiction over a defendant in another state or from another state. Now, let me clarify something else. Each time you hear the word state, you can replace it almost always with jurisdiction, because that is the essential meaning of that word. Because you can be in the same state and be a foreigner of the state that you're living in, all right? Such as non-resident aliens. For example, you can have a so-called American Indian that's in Oklahoma that belongs to a tribe and lives on a reservation in Oklahoma. Now, if a cop just so happens to stop this Indian and give him a ticket on an Oklahoma highway, which is a summons to court, he would be a foreigner from one state being called into the forum court of another state, because as a so-called Indian, a member of a nation which has its own jurisdiction, you're not presumed to be within the jurisdiction of the United States. You're not presumed to be. That should make understanding this concept a little easier. State can mean a geographical difference or a jurisdictional difference. It's the context in which state is used that determines the meaning, not the word itself. Language and law is not much different than the contextual nuances in our everyday language. Anyway, reading on. The United States Supreme Court has decided a number of cases that have established and refined the principle that it is unfair for a court to assert jurisdiction over a party unless that party's contacts with the state in which the court sits, that's the venue court, are such that the party could reasonably expect to be hailed into court into that state. This jurisdiction must not offend traditional notions of fair play and substantial justice. Now, pay close attention to this next piece, okay, because it's crucial to your understanding of minimum contacts. A non-resident defendant may have minimum contacts with the foreign state or with the forum state if they, 1, have direct contact with the state, 2, have a contract with a resident of the state, 3, have placed their product into the stream of commerce such that it reaches the forum state, 4, seek to serve residents in the forum state, 5, have satisfied the Calder effects test, or 6, have a non-passive website viewed within the forum state. Okay. So that last one is crazy because they're basically saying if you have a website that another state can see, that someone in another state can see, and you solicit sales on some type of business with that website, you could have a minimum contact. And that is possible. But as we'll see, other things need to be considered because your site has to constitute doing business in that state, which being viewed is not necessarily cut and dry. So, as if we needed more confusion, now we have all these seemingly easy ways for your trust or corporate device to be amenable or susceptible to the court's molestation. But what we're going to do now is go through some quick case references to construct a general basis by which we can establish criteria for court jurisdiction. And it's basically going to come down to a case-by-case basis on whether or not the courts can claim jurisdiction over your trust or your corporation. That can be to your advantage because it depends on how you move. Because if there's no concrete guideline, then they have to prove their case and all claims against the privacy of your device. Your only need for defense is knowledge of jurisdiction in general. All right. The cases mentioned here are for corporations, but a trust doing business in another state, like a business trust or a trust that owns a business, would have the same minimum contact rules applied to it, since corporations and trusts are basically the same style of devices for people to conduct commerce through. So I mention those things because some people think that if they put their trust or they put their business in a trust, they can somehow circumvent business taxes. Don't do that. Just take advantage of the tax benefits you get organically. Trying more than that is complicated and dangerous, even for experienced people. All right. So now let's get into this case of Fielding versus Minnesota. Let me first give you a small summary of what's happening here. The grantor of 4 individual trusts, which is Reed McDonald, he was the active grantor and trustee of 4 trusts in Minnesota for 3 years, from 2009 to 2011. In 2012, a new trustee took control over the trust, named Catherine Boone. She resided in Colorado, but was the trustee of these trusts from 2012 to the middle of 2014. On July 2014, a man from Texas became the trustee over the trust, and this was William Fielding, the man who brought the case against the Minnesota Tax Commissioner. Right after Fielding became trustee, he sold the corporate stock held by the trust. So, a grantor of 4 trusts was the grantor and trustee for 3 years. Then he gave up control of the trust, the trustee position, to other trustees for the remainder of the trust timeline. He was only a trustee from 2009 to 2011. The Minnesota Tax Commissioner asserted that the sold stock profit, which was sold in 2014 after he relinquished control, she asserted that that profit was taxable to Minnesota because the trust was a Minnesota resident, meaning, of course, it resided in the Minnesota state. The commissioner believed that the trust was a Minnesota resident because, 1, the trust was funded with stock from a Minnesota corporation, and we see that here. The trust were funded with shares of common stock in a Minnesota corporation, and then they give the case law supporting the reason that because it was common stock from a Minnesota corporation, which is a creature of the state, that it could be taxed. Now, I've discussed this at some length in my trust course, and that was that the use of the debt instrument, which is called the dollar, is a contract with partners of the government, and it brings you, if you use these instruments with your trust, it brings you into U.S. jurisdiction. Now here we see that the commissioner's position via the court is that one reason she should be able to have jurisdiction of the trust is because it was funded by Minnesota corporate stock, which are in essence just like the tender stock certificates were given for payment of debts. Now her basis for claiming jurisdiction was that the stock was from a Minnesota corporation, which is a creature of Minnesota state. That is the connection that she claimed. Now we go here. And we see more confirmation of what her claims were. The reasoning that she should have jurisdiction to tax the trust. Okay. The commissioner contends that she can constitutionally tax the trust's worldwide income based on several contacts between Minnesota and the trust, asserting that the trust owe their very existence to Minnesota. Now, in her mind, how do they owe? Well, actually, according to the Minnesota rules, not her mind. But how do they owe their very existence to Minnesota? Well, the trusts were created in Minnesota with the assistance of a Minnesota law firm, which drafted and until 2014 retained the trust documents. So if a law firm forms your trust, that by default allows the presumption that it is amenable to the courts, that your trust is amenable to the courts. All right, that's very, very important to know. Another reason for the contention of jurisdiction is that one of the beneficiaries was a Minnesota resident at the time that the trust was formed. Here we see this again in her contention. Finally, one beneficiary, Vanderver McDonald, has been a Minnesota resident at least through the tax year at issue. So we clearly see here that the taxing authorities claimed a portion of the worldwide income of these trusts based on beneficiaries being U.S. citizens, based on the currency of the trust being issued from a state agency, and the trust being formed in the state of Minnesota using a Minnesota law firm. Now, this shows you the things that you need to be concerned with if you want to keep your trust private, if you want to keep your trust away from the jurisdiction or from the presumed jurisdiction of the state. Now, there's much more to this case, and it would behoove you to get your hands on it if learning about trust is your goal. But one thing I'll summarize for you is the fact that the tax commissioner tried to tax the trusts during the years when the grantor gave up control of them. Or rather, she tried to tax the trust far after the grantor relinquished control to trustees. And these were out-of-state trustees. But she was still trying to hold on to the jurisdiction of the income. From 2012 to present, the grantor was not the trustee, and they mention it here. And they mention it for a reason. On December 31st, 2011, grantor Reed McDonald relinquished his power to substitute assets in the trust as basically any control of the assets in the trust. The trust therefore ceased to be grantor-type trust and became irrevocable on December 31st, 2011. Okay, very, very important. And this is why I've been telling you guys in my course and in consultations. A trust where the grantor is in control is looked at differently. The grantor is responsible for the taxes if the grantor is in control, if the grantor is the trustee. The assets are not protected as they would be in an irrevocable trust or in an irrevocable trust. Okay, and here's more confirmation of that. The trustees, not the grantor, made all decisions regarding the trust, including whether to sell the stock in FFI, that is the Minnesota Corporation. These decisions were made entirely outside of Minnesota, and all 2014 trust records of assets and income were maintained outside of Minnesota. Okay, the trustees never traveled to Minnesota for trust business in 2014, and were never plaintiffs or defendants in any other suit before Minnesota courts in their capacity as trustees. When the full context is viewed, it becomes clear that the trust did not enjoy a level of services. Now we're going to look at the difference at how a resident trust is taxed compared to a non-resident trust when the grantor is not in control. So we'll look at the divide in currency when the grantor owns the trust and when an out-of-state trustee owns the trust. And you'll see why it's important. You'll see why jurisdiction is important. The trust then filed amended tax returns claiming refunds for the difference between the taxes owed as resident trust and taxes owed as non-resident trust, a tax savings of more than $250,000 for each trust. Now we're talking about 4 trusts here, so that's $1 million. So summarize. When the grantor owned the trust, if Minnesota had taxed the trust for these tax years, for the tax year of 2014, with the selling of the stock, if that would have been taxed as a grantor trust, it would have cost a total of $1 million more than the trust being taxed as a non-grantor's trust, with the trustees being outside of the state. And they filed an amended tax return claiming refunds for the difference between the taxes owed for the grantor-owned trust, or what taxes would have been for the trust as a grantor trust. The difference they paid was $1 million more. So they wanted that back. They filed an amended return claiming that they were owed a refund for the difference of the grantor type trust taxation and the non-resident type taxation. Okay, hope I made that clear. Now this is important. Minnesota statute claims that the grantor trust may become irrevocable when the grantor passes or gives up control. But in Minnesota's exclusive rules, the trust then becomes resident trust, even if the trustee is in another state, because Minnesota does not automatically recognize the trust as being domiciled where the trustee is. That's why they made that rule, because they anticipate people will have alien trustees to bring trust administration outside of Minnesota rules. So they put in place a law that allows them the presumption to tax the trust as if the trustee was still in the state, as if the trust was still a resident trust, which is not when the grantor gives up control and the trustee is outside of the state. It is not a resident trust. Now, Minnesota put this rule in place because if people don't challenge it, they can still be taxed. They got away with it until it was challenged in this case, and Minnesota lost. The real case, or rather I should say, read the case and it will become more clear to you if it's not already. Because what happened here is that the trustee said, now, if I'm in Kentucky, when the grantor gives me control of the trust, that trust administration is coming from Kentucky. You don't automatically retain the right to tax the trust, even if it was formed in Minnesota, the state who's claiming to be the tax authority. And this trustee, Mr. Fielding, took him to task and won. Now, that was not the only contention made against the commissioner, but that was one of the reasons they fought the taxing authority. And the judges agreed. As we see here, we conclude that the contacts on which the commissioner relies on are either irrelevant or too attenuated to establish that Minnesota's tax on the trust income from all sources complies with due process, meaning that their rules don't comply with due process. There's not due process. We reach this conclusion for the following reasons. Very important. A trust is its own legal entity with a legal existence that is separate from the grantor or the beneficiary when it is a non-grantor's trust. Okay, this is what they're referring to, a non-grantor's trust. The citizenship of the trustee and not the seat of the trust, meaning not where the trust is, not the residence of the trust, or not the residence of the beneficiary. Those are not controlling factors. The citizenship of the trustee and not the seat of the trust or the residence of the beneficiary is the controlling factor. Here, grantor Reed McDonald is not the taxpayer, the trusts are. Moreover, regardless of the grantor's personal connections with Minnesota, after 2011, he no longer had control over the trust assets. Okay, they're setting them up for the crash right here. Given their reasons why the commissioner's claims to be able to tax this trust are invalid. Now keep in mind, had the trustee been a Minnesota resident, this case may have been different, especially given the fact that it was formed by lawyers. But the revocable-irrevocable difference would still apply as to who has the power and responsibility. The leg up in this case was the out-of-state trustees. However, we can clearly see the particular jurisdiction effect in this case by the mentions of A, all decisions of the trust were made outside of Minnesota jurisdiction. B, the case purposely notes a jurisdictional change in noting that the grantor relinquished control in 2011. C, the case stated that a trust is its own legal entity, clearly separating it from the grantor once a trustee is assigned, irrevocably that is. And we see the financial burden gap between a trust under one state taxation, that's as a grantor trust, as opposed to another with a trustee that's out of the jurisdiction of the foreign state. These factors leave no doubt as to the differences in administration by a grantor and a trustee. Now, all this is only relevant if you're doing business with your trust, but also this information is valuable if you have a private trust or corporation. Now, a quick question that I'm asked often, and one I probably didn't clarify enough, and that question is, does banking place you into court jurisdiction? The answer is it depends. Generally, it does not. All right, let me show you something very, very important. If we go back to Wikipedia, their explanation of minimum contacts, and if you remember, they said you can incur a minimum contact if you have a contract with a resident of the state, or rather a contract with a person in the jurisdiction. So if you get a bank account, is that a contract with the state resident? We have to look at the legal rule of being involved in commerce to produce a minimum contact, and that is doing business in a state. If you're doing business in another state, you incur a minimum contact. Now, what's doing business? Is banking doing business? It can be in some cases, but most states exempt banking from the doing business rule. Now, we look at the Fine Law Legal Dictionary to see the criteria for doing business and its relationship to banking. All right. Transacting business out of state. A company that has a physical presence in a state or repeatedly engages in business transactions in that state is conducting business within that state. Most states will consider the following transactions intra-state business when they occur within a state's borders: sales of goods or services, providing services or labor, construction work. Most states will consider a company to have engaged in interstate business when it has employees in another state, owns or rents real property, or uses a warehouse in another state to ship merchandise to customers in that state. Most states exempt the following activities: mail order and telephone sales, a national advertising campaign, sales conducted through independent contractors, appearances in court, holding bank accounts or collecting debts in that state. Right? But if you really want to know how to determine the doing business rule in your state, you go directly to the authority who does the taxing. For example, in California, it's the California Department of Tax and Fee Administration. In Texas, it would be the Texas Comptroller of Accounts. It differs from state to state. So whoever does the taxation for business and sales in your state, that agency's definition of doing business in a state would be your basic guideline on how you would define or how you would categorize what is considered doing business in a particular state or within your state. Now, federal tax regulations apply to all 50 states, of course. So let's see what the big boys say about what doing business in a state is. All right, we're here at the big boys site, the IRS. Trade or business defined. The term trade or business generally includes any activity carried on for the production of income from selling goods or performing services. Now again, we see that the term trade or business generally includes, again, this is not the full scope of what they define trade or business is, but they are able to leave this door open so that they can categorize other things as trading business. It is not limited to integrated aggregates of assets, activities, and goodwill. okay, that comprise businesses for purposes of certain other provisions of the Internal Revenue Code. Activities of producing or distributing goods or performing services from which gross income is derived do not lose their identity as trades or businesses merely because they are carried on within a large framework of other activities that may or may not be related to the organization's exempt purposes. They basically say no matter how you cloud or how you cloak your business or anything that is extricating income from another state, if they can determine that it is doing business, no matter what the external device may look like or what device it is in, such as a business within a trust, right? They can still claim that as a business doing business in a particular state, all right? All this is very convoluted, but we know what we're dealing with. So the purpose of going over all these definitions describing doing business in the state, all that shows that none of it describes banking as doing business in a state. None of it. If banking is not doing business for a foreign person, for foreign person, state, or jurisdiction, it's not doing business for a resident of the state. Also, these doing business examples make it easier for you to form a general concept of what activity falls under the DBA category, thereby making your trust administration a little easier when it comes to out-of-state dealings or keeping it private.
Babysit, throne made of baby skin, donated by natives that procreate in sin. They gon' need to raise the rim. They gon' need a cage in that gymnasium. I play to win, Will Still Chamberlain. Put the globe on my middle finger and made it spin. They gon' need to raise the rim. They gon' need a cage in that gymnasium. I play to win, Will Still Chamberlain. Even Damien and Satan is afraid of him. I heard the devil's Tasmanian. Raps made them spin fast, hailing winds. Abstract radiance underneath my cracked cranium is gas.